Welcome to Employment Law This Week. I'm George Whipple. States take the lead on AI legislation. Artificial intelligence is rapidly changing the workplace. States and local governments are out in front of this transition, introducing new legislation and updating regulations to stay ahead of the technology. Epstein Becker Green's Eleanor Chung tells us why it's no surprise that this action is taking place at the state level.
Justice Brandeis famously said that the states are laboratories of democracy, and we're definitely seeing that with regard to AI in the states. We see that with the difference in the intent versus impact tensions in the states.
For example, Illinois recently passed a law to codify the disparate impact theory of liability, which focuses on effect, not intent. And California has long recognized this theory. Therefore, the AI regulatory frameworks in these states should be interpreted to incorporate this theory.
Texas's Responsible AI Governance Act, or TRIGA, went the opposite way. Disparate impact alone under that legislation doesn't establish a violation. You have to have evidence that the tool was built with discriminatory intent.
Some of these laboratories are pushing the envelope, taking novel approaches to regulating AI. Epstein Becker Green's Nathaniel Glasser tells us about legislation that has stood out to him.
One of the more innovative states we've seen is Connecticut, which in May 2026 passed SB 5, or Public Act 26-15. That law regulates the use of automated employment-related decision-making technology. As of October 1st, 2026, any employer that executes a reduction in force qualifying as a mass layoff under the Federal WARN Act must provide written notice to the Connecticut Department of Labor disclosing whether the employer's use of AI or other technology was a contributing factor to the reduction in force.
California's SB 947 targets the back end of employment, not just hiring. Most laws focus on screening and hiring. SB 947, on the other hand, is aimed at discipline and termination. It would bar employers from relying solely on an automated system for disciplinary or termination decisions and require human review with independent corroboration before acting on the output.
Notwithstanding the focus of many states and localities to regulate the use of artificial intelligence, including in the workplace, we are seeing resistance from the federal government as well as some backpedaling from certain states. For example, in Colorado, its original AI Act was delayed twice, and then it was paused as a result of litigation that was filed by XAI and joined by the Federal Justice Department. Ultimately, Colorado lawmakers repealed the original act and passed a new law that focuses on notice and disclosure.
This space is moving quickly, and every jurisdiction is handling regulation differently. So it's important to stay up to date.
To help our clients keep track of all of these developments, we've created a state AI law tracker that includes an interactive map for ease of use.
You can find that tracker at ebglaw.com/AI map. Thanks, Nathaniel and Eleanor, and thank you very much for watching. We'll see you next time.